Great, ladies and gentlemen, good evening. Well, ladies and gentlemen, welcome to the Geneva Center for Security Policy, and also welcome to this reality check. The reality checks, so the security in law, a reality check, that's an event series that looks at how international law works in security affairs, or how sometimes it doesn't work. And today we're going to look at a little bit of the dark side of humanity, so mass atrocities, and more importantly, since we have a pragmatic idealist here today, we're also going to look on prevention and what we can do about it. So you might think, or even say that, well, we're coming a little bit late, we're way too late. And I think that on the one hand you might be right, because we have 7 years of merciless slaughtering in Syria, we have atrocities in Myanmar, we have pitiless conflict in Yemen, massive human rights violations in Venezuela, among others, etc., etc. And all this is just happening in front of our eyes. But not only that, we have the bad taste of a déjà vu, thinking of Rwanda and Srebrenica. And more importantly, even, I think, what is occurring is we're kind of getting used to it. We hear oftentimes the argument, well, that's just the way it is, mass atrocities, that's part of conflict. Well, we're getting used to it. And I think that, in a sense, is the reason why we're not too late. We're maybe late for such a discussion, but we're not too late. Because if you take the prevention of mass atrocities as a serious thing, well, you see that in the end, every day is the day when it starts, the prevention and the combating of mass atrocities, and every day is when it continues. And so, the big question then, however, is where do we stand, and also where do we go from here? And who could not be a better interlocutor, someone who can give us the compass for these reflections than the Honorable Professor Gareth Evans. Having said that, I think the Professor, the Honorable Gareth Evans, is one of the few that we do not need to introduce. However, it would be a lack of respect if I wouldn't point out some aspects of his legacy. So the Professor, the Honorable Gareth Evans, is Chancellor of the Australian National University. Gareth Evans was an academic lawyer playing an important role in Australian constitutional and civil liberties law. He was a member of the Australian Parliament for 21 years and Cabinet Minister for 13 years. That in the posts of Attorney General, Minister of Resources and Energy, Minister for Transport and Communication, and in the end, Foreign Minister. And as such, he was a driver in developing the UN Peace Plan for Cambodia, the Chemical Weapons Convention, the Asian Pacific Economic Cooperation, and much more. And after his career, he was President and CEO of the renowned International Crisis Group. And Professor the Honorable Gareth Evans has widely published books and articles and is associated to the finest academic institutions in the world. For us today, the most relevant and interesting part, maybe, is that Gareth Evans has co-chaired the International Commission on International and State Sovereignty, on Intervention and State Sovereignty, leading to the 2001 report on the responsibility to protect and the following initiative. So a report that we all grew up with, and if we don't know it by heart, we definitely recall that we had to study it for our exams, and we were passionate about it in the evenings, etc. So really, really impressive track record. So Professor, thank you very much for being here, and thank you for taking time to share your thoughts with us today. And we've been saying thank you, also thank you very much for being here. And what I would like to stress is that I'm going to start with some questions, but actually my ambition is actually to give the mic as soon as possible to you, so that actually you can engage, ask questions, and really take over the discussions. So if we delve into the substance, as I said, the concept of responsibility to protect was introduced for the first time in 2001 by the International Commission on Intervention and State Sovereignty, which you had chaired. So in 2005, the World Summit adopted R2P as a doctrine by consensus. And so looking back, well, it seems that, well, that was a major achievement. That was really, like a president nowadays would say, that was huge. The question then, however, is, well, was that it? Was the job done? And where do we start now? How does it, where are we standing? How do things look? And especially, Are there any lessons or any takeaways from the entire process?
Well, thank you very much, Tobias, for that introduction. Thank you all to GCSP and all of you for being here today. Just before we plunge into answering that and other questions, can I just take 1 minute to acknowledge with sorrow the passing last month of my co-chair of the International Commission on Intervention and State Sovereignty, the late Mohammed Sanoun, who was a long-time resident of Geneva, would be known to many of you here for the fantastic role that he played over many, many years as a diplomat, as a servant of the UN, as a servant of the international community. A delightful man, fantastically good at defusing tensions, not least in the crafting of commission reports when confronted with a rather adventurous and sometimes over-exuberant Antipodean colleague, namely me. A wonderful man, and whose passing is a very, very sad occasion for all of us, I think, in the international community. So having put that on record, as I wanted to in my first visit back here in Geneva, because he only died just last month. Let me get to the nub of your question. Of course, with the horrors that have happened in Syria and Yemen, and the Rohingya people in Myanmar, and continuing anxiety about so many situations in Africa and elsewhere, it's very, very easy to be cynical and completely depressed about the state of affairs with the responsibility to protect. Very easy to dismiss it, as a number of critics now are dismissing it, as a complete waste of time, a complete bust. And obviously, there are huge challenges in terms of the effective implementation of the principles responsibility to protect in those very hard cases that have been going so spectacularly wrong. But let's try right from the beginning to put this thing in context by making clear that there are really 4 separate things that we who created the concept and implemented it initially were trying to do. And I think against 3 of those 4 benchmarks, we're actually not doing too badly at all. The first benchmark was to try to create a new normative principle that had hopefully universal acceptance, replacing the previous almost complete indifference of the international community, this belief that atrocity crimes, mass atrocity crimes, genocide, war crimes, crimes against humanity were simply not everyone's business, but no one's business. That sovereignty was effectively a license to kill. There was nothing much any of us could do about it. We had to cut through that. And that's really the prime objective of crafting the principle and seeking to get it embraced by the international community. And when we look back on the extent to which there has been buy-in to that set of normative principles, I think the story is really a pretty good one. And the best evidence for it are the annual debates that are taking place most recently in September this year in the General Assembly, formalised for the first time this year, not just taking place in a side session, but mainstream chamber, mainstream recorded business. And every year since 2009 there have been these debates, and every year it's been evident that the overwhelming majority of the international community, overwhelming majority of states, are completely in support of all 3 of the R2P principles, namely the responsibility of each state not to perpetrate atrocity crimes against its own people or allow them to happen. Secondly, the responsibility of other members of the international community to assist states that want assistance in meeting that objective. And thirdly, the responsibility of the international community, the collective responsibility, to respond appropriately, including in extreme cases where the Security Council supports it through military action, where a state is manifestly failing to meet its responsibility to its own people. All 3 of those principles are overwhelmingly accepted. Of course, it is the case that the first 2 principles are much more within countries' comfort zones than the third ones, and that's made very clear over and over again. But there's only a handful of countries, and they're the old familiars, the Cubas, the Nicaraguas, the Venezuelas, that from the outset have said we really, even though we signed up to it and supported the unanimous decision of the World Summit in 2005, we really think this is an unacceptable intrusion on state sovereignty. You get a little bit of that recurring theme from just a handful of countries, but overwhelmingly there is support for the basic principles, even from countries like China, who so long have insisted on principles of non-intervention, internal affairs and so on. Russia hasn't been very helpful, certainly not this year. in the debate, and it started to raise some more generalised objections. But really, over the course of R2P history, not even Russia has been a problem when it comes to normative embrace. It's been a big problem in terms of practical implementation, but that's another story. So I think it is very important to recognise that we're in a very different place than the world was, 2001 when our report came out, 2005 when it was unanimously embraced by the General Assembly. I'm not suggesting that any of the things that are involved in those principles have moved beyond principles to the point where they in any way amount to customary international law. That would require a much greater degree of buy-in in terms of practical implementation than has been the case. I don't pretend that for a moment. But that wasn't the attempt from the beginning. It wasn't to change the law, it wasn't to make new customary law or any other kind of law. It was simply to build on the principles of international human rights and humanitarian law that were already there, Genocide Convention and elsewhere, and win political acceptance for the absolute necessity to do something about these cases when they erupted. So that's the first benchmark. The second one, I'll be quickly about the others. When it comes to operating as an institutional catalyst, a catalyst for effective institutional response, R2P has really done quite well. We now have, in 60 countries or intergovernmental organisations, so-called R2P focal points, identified officials whose day job it is to monitor these R2P type situations as they're occurring around the world and to mobilise an effective response within their own country, their own institution. Admittedly, some of these officials are paying a little bit more lip service to the role than others, but many of them are taking it very seriously, and it does indicate the willingness to give practical content to this otherwise abstract norm. We do have a lot more effective civilian preparedness to deal with engagement, assistance, support and ultimately intervention strategies than was previously the case. We do have much more military preparedness in terms of so-called mass atrocity response operations, MARO, doctrine training, rules of engagement, this sort of stuff, because military operations, whether in support voluntarily of a country that seeks assistance or, of course, in the extreme case of Security Council authorised interventions, military operations in atrocity cases are not quite the same as traditional peacekeeping operations and certainly not the same as full-scale war fighting. They are something in between. There needs to be a whole lot of thinking about how to do this, and that thinking has been occurring. We've also had a significant degree of institutional evolution, of course, with the international judicial system and in particular the emergence of the International Criminal Court as a parallel development, but a very important one in support of R2P principles. The International Criminal Court has, of course, been under assault from some African countries, some Asian countries like the Philippines, and now grotesquely from the United States with the indefensible assault on the court that's been mounted recently by the Trump administration, the awful Mr. Bolton in particular. But nonetheless, ICC does deserve and demand our respect. It is tenaciously hanging in there and is a very important institutional vehicle. And I think R2P has been one of the catalysts for the consolidation of such influence as the ICC has. The third benchmark against which you have to assess the effectiveness when you're thinking about what we are trying to do is responsibility to protect as a preventive mechanism, an effective preventive mechanism. That's really the heart and soul of all this stuff, and over again the rhetoric of the international community makes clear that's where people's hearts are, and properly so. The trouble, of course, with prevention is that when you succeed, nothing visible happens, therefore nobody notices, and it's very hard to ever record success in a way that's seen as credible. But by and large, R2P has been an important energiser for a lot of preventive strategies in a lot of countries, and has been an important part of the explanation of why there has been no recurrence of atrocities in Kenya since 2008. It's an important part of the explanation why there's been no recurrence of atrocities in a number of West African countries since, in Kyrgyzstan since 2010. It's also an interesting and I think important part of the explanation why a country like Burundi, which for years has been on the edge of a volcano, waiting for another genocidal explosion to occur, hasn't yet exploded, because every time it gets close to the edge, the Security Council meets and there's intense scrutiny and discussion and debate about what kind of dampening down strategies. And this is all motivated by R2P in a way that would have been unthinkable when we go back to the days of Rwanda and the complete indifference of the international community to the evolving horrible situation there. So even though there's a preventive toolbox that is now very well understood, long-term structural measures, short-term operational measures, whether they're legal and constitutional, or going to economic support, or going to security sector developments, or whatever. It's a whole bunch of those strategies which are now very much part of people's internalised thinking and planning. So we've come a long way over the last 20 years, and I think R2P has been a big energiser of that attention to preventive strategies. But where finally the rubber really does hit the road, the fourth benchmark was an effective reactive mechanism. When prevention had failed, when atrocities actually occurring, will we be able to mobilise the international community to respond effectively to them? Here, of course, the story has at best been mixed, and probably to be objective about it, hasn't been really a good story at all. Some good stories, I mean, Côte d'Ivoire, early 2011, Libya in the first part of 2011, although that went very sour shortly thereafter. Kenya in 2008, the elections that exploded into genocidal violence, or potentially genocidal violence, not responded to by any military operation, but by an effective diplomatic mobilisation by Kofi Annan, the UN, the African Union. Really classic demonstrations of R2P principles at work, and pretty successfully applied. But then things went off the rails. It's a long and complicated story, we might get to it, but with Libya in 2011, when what was initially a classic demonstration of R2P working exactly as it was meant to, with prevention having failed, situation exploded, Gaddafi engaged in one-sided violence against essentially unarmed demonstrators, and then mobilising troops to march on Benghazi with the prospect of a massacre of thousands of people. The international community being really energised, mobilised, Security Council endorsing military response and succeeding in stopping that massacre. But where Libya went wrong, and this is the source of most of the problems I think we've got in the Security Council to the present day, where Libya went wrong is what was clearly a very narrowly and carefully defined civilian protection mandate was pocketed and transferred into a full-scale regime change mandate by, frankly, the P3, France, United Kingdom, United States, who said they weren't going to rest content until Gaddafi was actually captured, killed. Without thinking through just the implications of that in terms of maintaining trust, confidence, consensus on the Security Council. That was seen as going further than the mandate was intended to go. It led immediately to the breakdown of response to the situation which was emerging in Syria at about exactly the same time in 2011. Almost a replica of the Gaddafi situation in the early days in Syria, when you remember Assad began by basically attacking unarmed demonstrators in the capital. And instead of the Security Council responding, as had been the first step in Libya, with a motion condemning that violence and threatening criminal court prosecution and applying arms embargoes or threatening sanctions or applying sanctions, instead of the Security Council doing any of those things, there was not even a condemnatory resolution, because basically Russia, China, India, Brazil, South Africa, all the other members of the Security Council at the time were so cheesed off with the way in which they thought they had been played by the P3 in the Libya case. They said, we're not even going to let you get to first base on this. We give you guys an inch, you take a mile. And that breakdown, of course, has been catastrophic in its wider implications. Not only did it embolden Assad to go on doing what he did, so that we had a one-sided violence turning into a full-scale civil war, which continues to this day, but we had a complete breakdown in the possibility of consensus on the Security Council. And the big task, of course, is to try to recreate that consensus. Maybe that's an issue we can come back to. But the bottom line that I want to leave you with is, when you look at those four benchmarks: normative force, institutional catalyst, preventive mechanism, reactive mechanism, R2P is really alive and well and flourishing in the first three of those, not doing so well in the last, not doing at all well. But let's be disheartened about that. Let's just regard that as a new challenge which we've got to try and surmount.
Thank you very much.
So that was a long answer, but we won't be nearly as long with the others. But
it's quality, not quantity, that matters. So, thank you very much, and thank you very much for giving this really very conceptual, really solid, but also very insightful and practical exposure to the issue. Well, so I'm sorry, maybe if we're going down the road where the challenge lay and not the accomplishments. So maybe I have to apologize for that already now. Because it makes the debate maybe more interesting, but also harder for you. You mentioned Libya, you mentioned Syria, you mentioned the UN Security Council, you mentioned military forces. So to go really straight to the point, well, following the debacle in Libya in 2011, then Brazil came up with the responsibility while protecting. So saying, okay, we have to bring that a little bit further. There has to be a criteria that have to be discussed before using force. And also there has to be a review mechanism. So the question would be, did this initiative lead anywhere? Are there any lessons here? And maybe we can, since you already touched upon several issues, then go a step further to the latest news, where we say, okay, there were use of chemical weapons in Syria. And in the end, I mean, 2017, but especially 2018, there were strikes by the UK, France, and the US in retaliation of the use of chemical weapons. And what we see is that France and the US, they didn't even bother to give a legal justification. On the other hand, the UK clearly said that it was legal according to the principle or the premises of humanitarian intervention. So here we're having R2P, we're having responsibility while protecting, and now we have suddenly the emergence again of humanitarian intervention, like a little bit of a zombie that is coming back that we might thought we had eradicated. So how do you see those concepts? How do you see the current scenarios? How do you see the deadlocks, etc.?
Well, a lot of things wrapped up in those questions together. First of all, responsibility while protecting. If you're looking for a way to recreate consensus in the Security Council following the debacle over Libya and the very negative implications of that for Security Council decision-making subsequently, I think the Brazilian proposal going back to 2011 of RWP, responsibility while protecting, is and remains the best way forward. And I think it's very important to keep that particular flame alive. Of course, if the dreadful Mr. Bolsonaro gets elected in Brazil, we're not going to be hearing much more from Brazil about anything remotely humanitarian or credible, but at least the idea was a very important one when it was articulated in 2011. What is the idea? The idea is essentially very, very simple. When stripped, there was a lot of debate about it, but when it's stripped down to its essentials, it is, as you say, has two components. One was that if a military mandate is to be granted by the Security Council, then it should only be after very careful and detailed and self-conscious attention is given to the criteria of legitimacy. And I'll come back to what that means in just a moment, for the use of military force. That in order to build a genuine consensus, in other words, not just a transient consensus or a response to passing pressures that people feel, but a genuine consensus, there should be attention paid to those understood criteria. Not criteria of legality, but criteria of legitimacy, and the maximum possible buy-in should be reached. That was the first part of the proposal, and seems to me to be eminently sensible. The second part of the Brazilian proposal was essentially there should be some kind of monitoring and review mechanism, not necessarily very formal, but one to which there was genuine buy-in by all members of the Security Council, such that when a military mandate was given in an R2P situation, or indeed any situation, but an R2P one, let's assume, there would be regular review of how that mandate was being applied by the Security Council. The countries that were conducting the use of force would have to come back to the Council and explain whether the mandate was sufficient for the particular purpose that had been identified, the civilian protection purpose, or whether it needed extension or variation, and would give other countries an opportunity to say that the mandate's being exceeded and overreached and ought to be narrowed or concluded. We're used to sunset clauses, we're used to periodic reviews of mandates in the context of protection of civilians' mandates and peacekeeping operations. This is no big deal for the Security Council to accept. But it is offensive to some countries on the Security Council. I mean, the United States wants to preserve at all costs its divine right of ad hocery when it comes to dealing with these situations. And I'm afraid sometimes the US and the UK are not being very much better. And they're still reluctant to accept, even to this day, that they may have overreached in Libya in 2011 and caused the problems largely themselves that we're now confronting. But if that bites, that idea of careful attention to criteria and agreement on regular review, monitoring and reconsideration of the continued applicability of the mandate, if that could be agreed, then I think we could recreate consensus, because going back to the point I was making about the normative force of R2P, for all the posturing and the great power, thuggery and so on that goes on, the Realpolitik, I don't think anybody really wants to go back to the bad old days when these atrocities were occurring on a massive scale and the international community was just pretending that it was absolutely nobody's business. I think there is a genuine, moral obligation that is being felt, even by the most implausible of countries. And we ought to find ways of operationalising that moral sentiment and taking away the excuses they now have for not doing anything. Going back to the more general question about the use of force generally, we always need to remind ourselves that use of force is not the be-all and end-all of R2P. It's just one mechanism, and at the most extreme end of the spectrum, for dealing with extreme situations when they have got completely out of hand. Use of force against the will of the country in question, coercive force. It's only in those cases, and of course the bar is always going to be very high indeed, and it should be very high before the use of force is ever embraced. When we wrote our original report, we were very concerned to make clear that use of force needed to satisfy two big boxes, in fact 3 big boxes when you think about it, preconditions. It had to be legal, it had to be legitimate, and it also had to be practically deliverable. And we had something to say certainly about legality, something to say a lot about legitimacy. We didn't have a lot to say about practical deliverability, but in the real world that becomes very important indeed. So when we talk about any of these cases that you might want to get onto, about whether they're appropriate cases for use of military force or not, whether it's the response to the chemical weapons use in Syria and Douma in April this year, or whether it's Venezuela or whether it's Myanmar or anything else, let's just, before we get to any of those cases, let's just get clear what the basic principles are here, because they were pretty clearly articulated in that report and pretty clearly understood by, I think, the wider international community. First thing, when it comes to legality, there really is only one game in town, and when it comes to use of force in an R2P context, and that is Security Council approval under Chapter 7, or Chapter 8, the regional organisations, which is an alternative way of getting to formal approval. Other than in self-defence cases, which are very rarely the context here under Article 51 of the UN Charter. There is, from time to time, a rearguard effort mounted by the lawyers in the UK Foreign Office and sometimes by the United States State Department, some attempt to argue that there is now some kind of customary international law which justifies the use of force without Security Council approval in cases of impending or threatened use of weapons of mass destruction, or maybe indeed even in mass atrocity crime cases generally. As much as I would like that to be the case, I have to say, from lawyers' perspective, it's complete nonsense. You only get to be established as a rule of customary international law when there's a long record of custom and practice, together with endorsement by the great and the good among the international law academics and so on, but custom and practice. And you just cannot say that there's anything remotely resembling universal buy-in to non-Security Council authorised use of force in these sorts of cases. It just doesn't exist. So legality can only be satisfied by Security Council or Chapter 8 authorisation. Legitimacy is something else again, because I think it is now very clearly understood that some cases can be legal but not legitimate, other cases can be legitimate but not legal. Legitimacy involves satisfying multiple criteria, which have now been pretty clearly identified, not in any General Assembly resolution, not in any Security Council resolution. Nobody wants to go down the path of trying to debate these things and get formal agreement about it. But in the report of our Commission, in the report of the Secretary-General's high-level panel on threats, challenges and change, in multiple other commentaries, it's now pretty well universally accepted, I think, that there are 5 criteria of legitimacy which really ought to be satisfied before you go down the path of using force, not only in R2P cases, but indeed in any case. First criterion is that the risk of harm, or the threat of harm, is such a character, nature, magnitude as to prima facie justify the use of force. There's no way of defining that more precisely in numerical terms, but there has to be some kind of threshold of seriousness of impending harm before you can even start thinking about it. So that's the first thing. The second thing is last resort. The notion that every other non-military... the second one is, let me go down in order. The second one is proper purpose, proper intent. This is the subjective criterion, very hard in practice to wrestle with and articulate and identify, but we sort of know it when we see it and know it when we don't see it. That is the primary motivation for the use of force in the case in question to halt or avert catastrophic harm being perpetrated, or is there some other motive, whether it's oil or bananas or whatever? Very often the case that there will be other motives in play, but is the primary motive, the main compelling driving force that justifies the case being made, is it the moral one of preventing, halting, averting atrocity crime? Third criterion of legitimacy is last resort. Is this the only reasonable way of addressing the situation, or is it the case that non-forcible options still have some prospect of success? This is often misunderstood, the last resort criterion, as requiring endless patience while you hang around while the weeks, the months pass and you wait to see if sanctions have worked or something else worked. No, it doesn't mean that. It means there being the reasonably available judgment that on all available information, nothing else is likely to stop the harm in question than use of military force. And this is exactly the kind of consideration which justified the Benghazi, the Libyan case. If you'd waited around to see whether sanctions bit or, whether Gaddafi really was going to be deterred by the prospect of International Criminal Court prosecution, there would have been 10 or 20,000 people dead and blood on all our hands as a result. So last resort doesn't mean waiting, but it does mean a reasonably available objective judgment. The fourth criterion is that of proportionality. Is the nature of the response in terms of its magnitude, its duration, its severity, proportional to the nature of the threat, the harm that's being caused or that you're seeking to avert. And again, I think part of the problem in Libya was that the force was appropriate to the civilian protection objective, but it was a disproportionate use of force to move up the scale to regime change. But the notion of proportionality, I think everybody understands. And the fifth criterion of legitimacy is really the most critical one in many ways, and it haunts the discussion and properly should of everything else. And that's the balance of consequences. When you put it all together and shake it, is more good than harm going to be done by military intervention? Or are you so uncertain about the consequences of military intervention, or so well aware that there is going to be catastrophic collateral damage involved to so many more people as a result of it, that it's just not a sensible course to undertake? Those criteria are all now very much part of the international debate. Very well understood. They haven't been codified anywhere formally, but they're the kind of thing it's very easy to use in the kind of RWP context we were talking about before. If people would only do a checklist in their contributions to these debates and work your way through it, it would, I think, be much easier to get genuine consensus, because when you work your way through those criteria, it becomes pretty obvious whether there is or is not a case for military coercion. The other great charm of those criteria are that, of course, while a lot of them owe their familiarity to traditional medieval just war theory in the Christian Catholic tradition, the truth of the matter is, when you explore the character of these principles in other intellectual and religious cultures, they're alive and well. I mean, you can find exactly those principles in Hinduism, in Buddhism, in Confucianism, in Islam, and so on. And I've done a bit of work, not with the primary sources, I hasten to add, but with the secondary sources, and it really is remarkable the extent to which there is a universality about these principles and a universal recognition of their relevance. So, criteria of legality, criteria of legitimacy, and a third box, really, criterion of practicality, because you can decide that there's a legal foundation for this and get that legal foundation, get a resolution passed. You can decide that the criteria of legitimacy are satisfied, but then you've still got to find the resources to actually exercise the military operation in question, and that can be a different story again. The big remaining question, let me just address it finally before we move on, is that what do you do in those situations? I'm asked this over and over again, where the criteria of legitimacy are manifestly satisfied, but for whatever reason, cynical, opportunistic, indefensible it might be, you cannot get a Security Council resolution passed because one of the big powers is exercising a veto, Russia or China or whatever. What do you do in those situations? Do you just accept that and say, well, under no circumstances can military force be contemplated because that legality criterion hasn't been satisfied, or is there some other way through it? We all want to think there's some sort of way through it when we confront these incredibly indefensible vetoes. And the Kosovo case in 1999, I think, is the one that sticks in most people's memory as a pretty, I mean, there's still one or two people take a different view, but basically people say this is the classic case of every criterion of legitimacy being satisfied, but the criterion of legality wasn't. Nonetheless, US, UK, France went in and did their stuff in Kosovo, and serious genocidal massacres were arguably averted as a result. Was that an indefensible thing to do? None of us really want to say it is, but how do you intellectually deal with that dilemma? It's very, very real. We struggled with a way to handle that in our report, and I'm not sure that we quite got it right. What I've found talking about this and thinking about this in subsequent years is the best way of answering this is, I think, by reference to the domestic law principle, certainly in common law jurisdictions. I think it's equally applicable in Roman law jurisdictions and others around the world. The idea of the plea in mitigation. The idea of the plea in mitigation. You don't contest that what you did was illegal, technically, but you throw yourself on the mercy of the judicial authority by saying it was so morally defensible in all the circumstances that I ought not to be actually punished, or not punished with any degree of severity. Yes, officer, I did run the red light. I acknowledge I ran the red light. I was in breach of the law, but I had to get my wife to the hospital. She's giving birth to a baby in the back seat. That sort of case, a plea in mitigation, utterly familiar, utterly morally familiar, I think, to all of us. And provided you don't overdo it, and provided you don't make that plea in mitigation every second week for some case, everything's an exception, I think you can live with the reality that from time to time there are going to be cases, and maybe the Duma, the response to the chlorine, even though it was thought to be sarin, it wasn't sarin, it was actually chlorine, and maybe that wasn't da-da-da-da-da. It was a defensible response, I think, in terms of the criteria of legitimacy, even though there was no legal foundation for it. I think Kosovo was certainly legitimate. But you've got to think long and hard before ever going down that particular path. But that's the way I would sort of try to navigate my way through that dilemma. But let's pretend that it's not a dilemma. It's a very, very real one.
Well, thank you very much for elaborating on that. It's interesting that you're bringing up the example of the red light and you cross it. I just recall Harold Coe, former legal advisor of Secretary of State Hillary Clinton, who said, well, similar example, you cross a red line, you get caught by the officer, well, what you do is you say it was legal. And if you get then, amended, you get a fine or something like that, well, then you pay the consequences. But if he doesn't, because he believes your story that it was legal, then you get away with it. But I imagine that is more like a power-backed legal position that maybe an American lawyer can have. Which
good try, Harold, but I don't think I'd buy that one.
But you mentioned...
Of course it's illegal, but this is the trouble. I mean, this is why you still get State Department legal people and FCO legal people trying to mount these indefensible cases for legality where none exists. Mount the moral case and let the chips fall where they may, but don't pervert the legal argument is my storyline on that.
Great, thank you very much. And you mentioned military preparedness before, but you also said that, R2P is mainly a preventive instrument and a preventive concept and the norms, etc. The question then would be, well, can you link one thing, namely use of force, together with the prevention, and that in general in security studies you talk about deterrence, like in a sense, is there a way of linking both together in a sense of saying, okay, you could say if you're going to do this and that, we are going to react and therefore actually threaten to react and threaten to harm, and that therefore actually, although military force or use of force is a reactive tool, actually have a preventive effect. Number one, is that something that you were thinking about? Number two, is this even feasible? Because what that would require is that the threat is pretty credible, that the leader does not commit mass atrocities because the leader is afraid of the reaction. Is that something that was debated? Is that something that is realistic, or is that something that even goes so down the cynical road of using force for humanitarian purposes that it's just not shouldn't be thought about?
Well, of course, it's the case that if someone about to embark on an atrocity course fears the risk of military retaliation, that is bound to concentrate that person's mind pretty comprehensively, but that's so many steps away from what one can be sure you'll be able to deliver, given all the hurdles you've got to overcome, the criteria that you've got to satisfy of both legality and legitimacy, that I think, the notion that this would have any immediate deterrent impact is pretty long bow to stretch. That said, if we do better at creating the kind of rapid reaction forces, credible response forces that have been talked about endlessly. I mean, we've talked about a UN volunteer force for decades, but that's frankly never going to get off the ground. But if the NATO response force, the NRF, can be thought of as an available resource, ready and willing and able to be mobilised very quickly to deal with these situations if all the other things fall into place, the other criteria fall into place. If the EU battle groups concept ever gets off the ground in any credible militarily deliverable fashion, so that you do have multilateral uniform personnel available and trained and ready and battle ready to go in these situations should they be called upon, then of course that might make a little bit more credible. It would at least satisfy the third basket of practical deliverability of that response. Whether you'd get the Security Council buy-in to give you legal cover for it, or whether you'd have so much legitimacy, satisfaction with the moral criteria in the middle that you'd be prepared to go ahead anyway without that legal criterion be satisfied. All these are things that would have to be satisfied before you could make that connection. Of course, the same sort of argument applies with respect to International Criminal Court prosecutions. You not only want to have an effective ICC system because you hate to see people getting away with stuff, and the notion of impunity is pretty horrible to have to live with. of course, it's also the case that if the ICC system was functioning properly and people were brought to trial and convicted with a reasonable prospect of being apprehended and having to serve their punishment, that would be a pretty systematic and serious deterrent for such things in the future. So it is important to build in deterrent capability where you can. But when we talk about prevention, I think overwhelmingly the focus is on other mechanisms, other strategies. It's trying to deal with the root causes of these situations. It's trying to put together, whether it's legal and constitutional strategies to give better rights protection for minorities, or whether it's economic strategies to get rid of economic grievance of a kind that can generate hostility, which results in group and ethnicity directed but basically economically driven hostility. I mean, there's all sorts of ways in which you can do things aimed at better governance. All of these things are a part of the preventive toolbox and eminently worth doing, both in a long-term sense and in a short-term sense, and endlessly worth putting more resources into. But if you can put a bit of icing on the cake with some deterrent capability of the kind we've been talking about, then so much the better.
Thank you very much. And I had some other thoughts and questions, but I think I'm going to limit to that because, based on the central role of the UN Security Council, and we see some blockages and the new, maybe coming back like homecoming of Realpolitik and what that means with balance of power and spheres of influences, etc. So the question of the future. But I think you already addressed that question a little bit because you said that no, I mean, in the end, nobody really wants to go back to the bad old days, and so I think maybe we can leave it from my side at least here, like in the sense that it's really there's a long way now behind, and there's really an ongoing process, much engagement, and still much more to do. And with that, I would really like to open the floor to questions, whatever be, may be case specific, may be conceptually, may be legal. Really, we have the master here, so please feel free to just engage. And I see Tim. Thank you.
Yeah, thank you very much for coming.
Sure.
Could
you all please introduce yourselves?
Yeah, Tim Reid. I'm a recovering peacekeeper. I've actually worked on the front lines of most of the places you've mentioned. Former fellow here at GCSP. I have to say, noble concept. I honor your attempt to turn it into a norm. However, I think really this is rose-colored glasses, and I think the glass is about 1/10 full, and I'm not even sure whether that doesn't do more damage than good. When we look at many of the issues you've talked about, there was Sherbrigg, which was created as a military force for just this sort of thing. It only ever was deployed to the absolutely most permissive peacekeeping missions. Many of the people that have been responsible for the worst atrocities not only have not been arrested or punished, they've actually been supported and financed. You look at Rwanda, where the RPF, which was the initial aggressor and which most evidence shows actually shot down the plane, that investigation was squashed. The investigator was fired by your successor at ICG, Louise Arbour. The RPF regime was then supported with Western aid in its invasion of the DRC. 6 million deaths later, while again Louise Arbour is a High Commissioner for Human Rights, never ever mentioned at all the role of Yoweri Museveni, Paul Kagame and their regimes. More grotesquely, in 2017, peacekeeping conference in Vancouver, lots of happy snaps with the head of UN peacekeeping, Canadian Defense Minister, James Kabarebe, one of the indicted war criminal, on a panel of protection of civilians in conflict. Rwandan foreign minister of this nasty regime has now been proposed by France as head of the Francophonie. You see the bombings of civilians and refugee camps in the Middle East with cluster bombs furnished by Western governments. You talked about Yemen. I mean, even Canada, my country, which recently was in hot water with Saudi Arabia and about some celebrity human rights cases, but did it stop us from continuing to sell armored personnel vehicles? No, it did not. So you see in peacekeeping missions, again, more generally, more and more, the countries which actually have some military might that could provide effective forces are reluctant to provide these forces at all, except to the most cushy headquarter posts. And then instead we get many forces who absolutely either just want to sit in their camps or even recycle war criminals. Anyways, I don't want to take up too much time, but you get the gist of what I'm saying. So I wonder if you could sort of respond to these, and particularly about the hiring of Louise Arbour to ICG, which to me seems pretty egregious.
Well, I don't want to get into personalities. I had no role in the appointment of my successor. That was a matter for the board, and it's certainly not for a CEO to appoint his successor. And that's another story for another day, how that institution evolved. But look, two problems what you said. You said in passing right at the beginning, and just left it hanging, that you doubted not only whether R2P had been any force for good at all, but you actually said you thought it might have made the situation worse. If you're going to make that sort of claim, I want that documented in chapter and verse. I've heard it said by some people and some academics that write stuff saying there's a new moral hazard factor has emerged because you've got people willing now to take on things because that'll generate an international military response that'll give them greater stature and credibility to go on, doing more exotic anti-governmental behaviour that it can actually encourage bad behaviour. I've seen no practical, credible. What's that?
I can give you a couple of examples.
Well, you could try, but I mean, if it's going to be the KLA in Kosovo, I won't believe you. What's your other?
For example, you have Russia intervening in Ukraine and saying it's doing it in other places as right to protect.
Well, for Christ's sake, it didn't use the responsibility to protect rationale at all in Ukraine. It did in Georgia, in South Ossetia, and it did not pass the laugh test internationally. It did not pass the pub test. It was a joke in very bad taste. Russia did not use R2P in Crimea. It did not use it in eastern Ukraine because it had been laughed out of court when it tried to use it in the Georgian case. Now, don't give me that, because you just can't sustain the case. It's an argument about moral hazard, and you can see that conceptually being possible, but in the real world, that's just not the way it works. But let me come to the more substantial thing. Would you really prefer that we had nothing at all? Look, I completely accept that there's an awful lot of cynicism out there, there's an awful lot of non-performance out there, there's an awful lot of utter disappointment in terms of effective implementation, all the ways we mentioned. But are we worse off for having a degree of international consensus now in the way that we had zero consensus in the 1990s? We had the North very obsessed about humanitarian intervention, but never prepared very often to do anything about actually delivering on it. We had the global South utterly resistant to the whole idea of the right to intervene. We've now at least got that conceptually together. We've got an acceptance of the basic principle that it is actually everybody's business. We've got an acceptance of the necessity for, institutional steps to be taken. We've got a lot of effective action taken on the preventive side, which doesn't ever get acknowledged, and we've got the failures, yes, on the reactive side. But are we worse off as a result? I mean, you really, really have to work hard to argue that, I think. And what you've got to do when you're confronted with this sort of disappointment, there's two kinds of people in the world. There's optimists and there's pessimists. There's pessimists who say the world's a crappy place, that people are going to always be motivated by selfishness, by greed, by ambition, or by idiocy, and there's nothing we're ever going to be able really to do about it. We just have to accept that reality. Or there's optimists who say the world's a shitty place and things keep on going wrong, but that just means we've got to recognise that we've got to work that much harder if we are going to get decency standards, common humanity standards, cooperative strategies effectively put into place. And look, if you approach life as a complete pessimist, you just don't get out of bed in the morning. At least if you're sort of optimistic and do put the rosy spectacles on occasionally and say with a little bit more effort and attention and we can make this actually work. Wheels do turn, things do change. Because otherwise just that sense of uselessness of everything is exactly the kind of thing that means that we'll never make the world remotely a better place. So I'm sorry, I can't go along with you at all, but don't let me get started because I won't finish.
Thank you very much. And just also from my side, what I can echo is like also in discussions, when you have discussions on US at Bellum or IHL, etc., with NATO lawyers, with American lawyers, even when you don't look for it, the R2P argument will come up, and the R2P rational oftentimes also will come up, and also from states or certain persons that you think, you know, they're the most skeptical. They're bringing the arguments up, and they're working with and really trying to see how to work and make use of it. I saw different hands up, so if I may give the word to you.
Bertie Ramcharan, we know each other.
We do.
Can I ask you to say a bit more about the 60 national focal points on R2P within countries? Mm-hmm. And is there one or more that particularly appeals to you? And how might one expand these national focal points on the responsibility to protect within countries? Thanks.
Well, interestingly, the most useful and successful of these enterprises was, under the Obama administration at least, the Atrocities Prevention Board. That was not just a single person, but a whole bureaucratic apparatus that was set up, you know, very much in response to the failures of intelligence, analysis and anticipation, as well as the failures of response and execution, to energise a whole of government response to these emerging cases. Very little in other countries that are as complex institutionally or as potentially sophisticated as that, but nonetheless it's now, there's a little organisation called the Global Centre for the Responsibility to Protect based in New York, which I chair the advisory board of, which keeps meticulous detail about this and chairs the annual meetings of the focal points and so on. And it's up to now 60. I think there's 55 countries and 6 international organisations, including, I suppose, the United Nations itself through the Special Advisor on Prevention, Genocide and Special Advisor on R2P. And the core idea is that you do have someone who, as I said before, whose day job it is, whatever else they're doing, and hopefully they're not doing too much else, their day job is to be a particular responsibility for identifying emerging situations that could satisfy these criteria and to alert their own government or their own organisation to that reality. And then, if the situation starts manifestly demanding an operational response, to be the focal point for the coordination of that operational response in country and out. And, you know, by itself it's not going to be the answer to all the problems, but it's a big step forward, because so often these things are divided in ministries among geographical desks or thematic desks, and it's nobody who's the sort of the go-to person. Unless, however, the person is of a sufficient level of seniority within the system to be able to make his or her analysis actually bite elsewhere and be taken seriously, then it's not going to be much use. And unless the person in question has, or the small office in question, you know, has enough concentration of responsibility on that task not to be totally diffused with 1,000 other responsibilities, then it's not going to work very well either. And frankly, in quite a few of the focal point countries, I think it's fair to say that a few of them are just of the, you know, they've done their day's work if they move something from their inbox to their outbox or into somebody else's inbox, and, you know, rather than being an energising force, that's just yet another layer of bureaucracy. But again, it's easy to be cynical about all this stuff, but all of these little steps are important parts of the total picture, getting in place an effective response mechanism in a way that the world was just hopelessly devoid of in the 90s, going backwards over the whole course of history. So, you know, things are going wrong, things are not going as well as we would like, but bit by bit by bit, there's still a determination to make this stuff work.
Thank you very much. Yes, maybe the lady in the third row.
Thank you very much. Hi, my name is Tamara Weir. I'm the managing coordinator of the support office of GAMAC. GAMAC is the Global Action Against Mass Atrocity Crimes, and we are trying to strengthen and develop national mechanisms to prevent genocide and atrocities. So my question is, towards prevention mainly, and you've mentioned it before, the 3 pillars of R2P. So while the first pillar is says that states have the prime responsibility to protect their people from atrocities, I feel that the focus so far has been a lot on the third pillar of R2P, and that the discourse around R2P is happening a lot in multilateral forums in New York or here in Geneva, and that is often also led by foreign ministries, people in foreign ministries. So my question is, how can we bring this discourse to the national level and to where prevention could really happen? How can we ensure political buy-in from states to build national architectures for prevention?
I don't think it's right to say that in the international discourse it's been consumed with Pillar 3. Huge amount, if you go through those debates year after year after year in the General Assembly, huge amount of concentrated attention is given to prevention, and at the national level, as well as through effective multilateral preventive buy-in strategies, because that is much more, as I said before, within countries' sort of comfort zone, because it doesn't offend traditional notions of non-interference and so on. So I think the starting point is one of extreme sensitivity to the point that you're making, and a willingness to, to do more effectively preventively. And I think the rhetoric internationally is very much on prevention. I mean, the trouble is, as with so much international rhetoric, it is rhetoric and is not accompanied by effective delivery strategies. But beyond that, I mean, all one can say is that if you're going to develop effective preventive strategies in country, then you're going to have to develop bottom-up pressure in each country through NGO activity and, like-minded sort of activity. I mean, a little bit of peer group pressure. There's always top-down pressure, bottom-up, peer group, if you're ever going to try to make anything happen anywhere in international public policy. Not much top-down stuff happening on this, but there's quite a lot of peer group pressure, and there's focal point meetings and all that sort of stuff. There's a lot of exchange. There's a lot of exchange of information about programs and strategies that they're doing. Sometimes helpful, sometimes just going through the motions. But what I would like to see a lot more of happening is NGOs in country really sort of focusing on just the point that you're making, just to try to identify. Is it a matter of, and countries that are in a position to assist other countries in preventive strategies, as well as countries at risk of atrocities doing better in terms of internal prevention. In all those cases, there's just a lot more activity than can occur, whether it's through the aid programs, not just economic assistance, but assistance in governance and capacity building and constitutional reform strategies and so on, security sector reform strategies, all of that. There's endless numbers of things you can usefully do in this area, and all I can say is that your organisation and others like you around the place, I'm delighted to see, are focusing more and more on the practicalities of this, and that's the way it's got to be. There's no magic bullet that I've got that can help solve that. It's just grinding away, and bearing in mind, that awful political reality. That although everybody talks the talk about prevention, there's not a lot of resources that people are willing to put into it, because, when it's successful, nothing happens, nobody gets credit. When you do a successful firefighting operation, when you're perceived to have carried the flag and done something to stop a situation carrying out, that's actually occurring, you get credit and reward and political reward or bureaucratic reward or international institutional reward. When you just do the hard grind of stopping a situation exploding in the first place, you get very little reward indeed. So maybe one of the answers to this is to find ways through all the human rights juries and things that exist around the place to better reward people who are doing good preventive things. Because, you just have to... We talk about, the Secretary General, Guterres, talks about a culture of prevention. It's flavour of the month. But delivering on it is very, very frustrating process, but we've got to keep at it.
Thank you very much. Yes, the lady all in the back.
Thank you very much. Good evening, Sophie Müller. You mentioned in a way that we could be optimistic on the outlook because there's this moral consensus about the importance of the R2P. And you almost said, oh, we don't have to worry that much, let's move on to other questions. I would like to challenge that a little bit, because we're living in times where we have international relations scholars posting letters, ads in the New York Times calling to defend the liberal system of international institutions, where you definitely could call the R2P to be a part of. You have the Khashoggi case, and Robert Kagan's word, he's saying the jungle is growing back. So might we run the danger if we're a little bit just thinking, yes, there's moral agreement, but at the same time the institutional foundations of that agreement are actually eroding. So could you elaborate a little bit more on that, looking ahead for the R2P?
I just got off a plane and my hearing is somehow clothed up. Can you just repeat the basic question again?
Yeah.
I just wasn't getting it clearly.
Sorry. So my question was, can we look ahead more for the R2P of what's going to come beyond this assumption that there is the moral agreement that you don't want to have to see mass atrocities and genocides? Because you could say that the R2P is part of the liberal institutional global order that we're seeing, which at the same time is actually more and more under attack. If you're thinking of the Khashoggi case, if you're thinking of scholars thinking we need to write letters in the New York Times to defend this order.
Well, is it part of the liberal international order syndrome, or is it something even more universal than that? Because maybe there's something, we talk about a rules-based order on the one hand, a liberal order on the other, and the liberal order has got all the democratic human rights sort of overtones to it, and that is in a sense under stress and under threat at the moment from new big players on the block who are much less enamoured of the democracy and human rights dimension than has traditionally been the case. What's the future of R2P in this context? I still think it has a future. It's just, if not as part of a liberal international order, just as part of a basically, rules versus anarchy based order, which by and large most countries are prepared to buy. I mean, my example here really is China. China's a fascinating case on this. You would think that China would be, because of all this, not just because of Tibet and Xinjiang and, the internal issues that it wants to conceal from the world's eyes, its own misbehaviour with respect to, arguably atrocity crimes. You would think that China would be indelibly hostile to this whole enterprise. In fact, it hasn't been at any stage. It was the crucial voice in Kofi Annan's high-level panel that was the transmission belt, really, from my commission report through to the 2005 World Summit. If that particular high-level panel had not picked up and run with and support, and Chinese voice on that was very strong, it was Chen Chichen, former foreign minister and very senior official. And he actually went along with it. He didn't contest it, much to my surprise. I was, but it was delight. And the Chinese have never really, even though they vetoed a couple of resolutions on Syria and so on, which are problematic, they've basically, in my conversations with them, at many different levels over the years, there's a recognition that they want to be part of a global order that has an element of decency and credibility about it, and they don't want to be, in a sense, on the wrong side of history. That's where they were on the Libya thing, and that's why they supported it. It wasn't just because the Arab League, gave them a bit of regional cover. It wasn't just because of other things. And there's a Chinese variation on the responsibility while protecting theme. There's a group of Chinese scholars that have come down around this notion of responsible protection, and they've written about it and talked about it, and when you go to Beijing, it's a very lively debate among the scholars in the think tanks and so on. So this is the cutting edge of the question about the future of the liberal international order against a country that on the face of it is not fantastically well disposed towards the liberal dimensions of that order. But nonetheless, to me, it's by no means at all a lost cause. I mean, Russia's a bit of a lost cause at the moment, because of the way Putin is behaving on multiple fronts and directions, and the complete cynicism with which it was using the R2P concept, if not in Crimea, it's certainly in the case of Georgia, and is being absolutely no help at all on any of this stuff at the moment. But the wheels do turn, and The way I often express it, I mean, is back in 1975, Henry Kissinger famously said to the Thai Prime Minister, or National Security Advisor of the day, 7 months after the Khmer Rouge had marched into Phnom Penh and the scale of the genocidal horror was beginning to make itself evident. What Kissinger said, and it's on the record, to his Thai counterpart was, "You can tell those Cambodians we'll be their friends. They're a murderous bunch of thugs, but we won't let that stand in our way." I just find it difficult now, 2018, all these years, to imagine anyone, anywhere. I mean, there's a lot of cynicism and there's a lot of misbehaviour and a lot of ugliness out there. And I know as much about as anyone. I've been in the middle of a lot of it over many, many years. I just don't see that degree of total cynicism about this. I think there is a sense that failing to deal with mass atrocity crimes, 80 million people killed in the 20th century alone because of their race, their nationality, their ethnicity, their class, their politics, not for anything they did, but for what they were. There's just a sense that, whatever else we screw up in the conduct of international affairs, whatever else we choose to prioritise, let's at least find a common acceptance that this stuff is intolerable. We'll always find reasons in particular cases for not doing the hard stuff and the hard yards or supporting military action or whatever. But that's why it is extraordinary when you read these General Assembly case debates. There is this degree of buy-in. It really is only the most, I won't use the Hillary Clinton expression, the deplorables, but it really is only the most recalcitrant group of characters in the international system that want to challenge this head on. A lot of the familiar suspects, that you would think would be deeply unhappy about this, are really willing to go along with it. So that's what gives me a degree of optimism for the longer haul. It's really, really hard work at the moment with these dynamics that we're all familiar with, but it's not impossible. And I do see, I think I see the way forward generally with China assuming this global leadership role. I mean, the big way forward is to get China really engaged in global public goods, regional public goods issues. It's already engaged on climate change. Yes, it might be an element of cynical opportunism there, jumping in to fill the hole that Trump so nicely abdicated for them. China, as the great defender of global free trade, is another bit of cynical opportunism, you might say, but also it's a recognition on China's part that there are big public goods issues out there which, if it can get its own fingerprints on and its own badge on, maybe it can do something to, give it some soft power in the new generation ahead. So China's a big contributor to peacekeeping operations. And, where's the cynicism there? I mean, are they really improving their long-term economic prospects in Africa by going into a few of these situations? No, I think they're doing it because they believe that it just comes with the territory if you're going to be a global player. So maybe I'm just naive, incorrigible optimist again about all this sort of stuff, but I really do think you've got to hang on to the positives that are out there and try to build on them rather than just say it's all bullshit, it's all a waste of time, we're all shouldn't be in this business at all. We must be in this business because, as Kofi Annan said in 2000, it defies every precept of our common humanity to stand by and do nothing when people are being slaughtered, just for their ethnicity or whatever. So, I'm not so pessimistic.
Thank you very much. I remember the hand in the first row.
Marc Finot, GCSP. Minister, you pointed to the blockages in the Security Council because of the abuse of the veto. How do you assess the French-Mexican proposal for the permanent members to abstain from the veto in cases of mass atrocities and human rights violations? Is this a form of whitewashing or a PR operation because it doesn't stand very much chance of being adopted, or is it a serious attempt?
No, I mean, as you know, Mark, I'm often cynical about French when it comes to nuclear things in particular, and I think they're absolutely genuine about this. I mean, I think there is a recognition that the veto has been constantly misused. You're never going to get people agreeing to formally do away with the veto. But if you can get that informal agreement not to use it in these kinds of cases, that would be a huge step forward. And as I remember, the French-Mexican initiative has now got buy-in from about 110, 111 countries, that order of magnitude. The ACT initiative running alongside that, Accountability, something Transparency initiative, which is trying to get other countries with aspirations to join the Security Council to also accept and argue for that principle of no use of the veto right. I think this is a very important normative development. It hasn't developed a lot of traction. It's very difficult to see, the Russians, the Chinese, even the Brits perhaps, buying into it just right now. And it's not going anywhere fast. But I absolutely do not dismiss it as just a cynical, branding exercise. I think they're absolutely serious, and good on the French government for doing that.
Thank you very much for those thoughts. Yes, sir.
Actually, good evening right now. My name is Mohammed Saleh. I'm CT coordinating Libyan government. I'm going over case Libya exactly. First thing, the resolution from the Security Council was mainly a political resolution, even they have some kind of the human right and something else. Then when they transfer that resolution to the military working in the field as a military. They don't think in exactly as the political. And they will never waiting for to make decisions. Sometime in their case, on their view, they will see there is a lot of palliative the role of the legality, and they will act like that. And from the Security Council, they will see that on the other side. And also the military, when they work, actually most of the time they is not exactly from the Security Council. They are following either way their command or their government. The other thing is most of the time the United Nations, they're looking for a problem from their view, where exactly Libyan problem or Libyan people, they see the problem from other side, and there is completely different. When they come to judge in that area, Libyan, they will take some decision completely different than other country or United Nations. The question, then they change the rule of the plain rule for the United Nations from one military to the other, to the commission in Libya, and then they don't give them actual enough tool to do in their job. Is that's what we see in the gap between all three decisions, is that they're causing more problem in Libya. Thank you so much for the cover.
Well, you raised sort of Libya-specific question, also a general question. As to the general issue, I mean, it is the case that militaries tend to do what militaries do, and they're not the most subtle of enterprises and not the most inherently containable of enterprises once you set them going with a particular task, which is why it's incredibly important to have, clear mission definition, task definition. I mean, part of the argument of the Brits and the Americans and the French was, you can't control a military operation with a 1,000-kilometre screwdriver. You've got to leave it to the military to get on with what it's doing. That might be true in an operational or tactical sense, but in terms of the definition of the mission and what's appropriate for the mission, I mean, it's certainly possible to control that politically, and certainly possible to control it, through the kind of mechanisms that we were talking about before, to ensure that things just don't go on over month after month after month of misapplication of the mission. But, alarm bells ring. One other thing to be said about the military, so many of these mass atrocity response operations are properly gendarmerie operations, they're tailored operations, they're quite specific. They're certainly not traditional peacekeeping operations, but they're peacekeeping plus, or plus plus, but they're certainly not full-scale warfighting either, because full-scale warfighting implies you do nothing except, get regime change. That's what wars are about. But that's why it is so important to have doctrine agreed training applicable, rules of engagement, all those things that are applicable to these particular kinds of quite distinctive operations. And that's why what I was saying before about the preparedness in a number of militaries quite around the world now that are giving serious thought and attention to the specific military requirements of these kind of semi-limited operations is very important. Look, in terms of the Libyan case, I mean, whether or not there was an alternative diplomatic solution available or political solution available is something about which there'll be endless argument. Certainly what the South Africans and others wanted to do after the Benghazi crisis was immediately over was to explore the option for a diplomatic political solution which would have involved hopefully some transition strategy with Gaddafi agreeing on a soft landing and leaving or whatever. There's a lot of scepticism around as to whether any such diplomatic initiative of that kind could have succeeded. But it's very hard to argue that it should not have been attempted. And had it been attempted and it had been obvious that there was no political diplomatic solution immediately in sight, it would have been that much more defensible, I guess, to continue the military operation for civilian protection reasons. But obviously also what went wrong in all of this, as has gone wrong in Syria and elsewhere, there's no obvious alternative. If you go in and break all the eggs and break the regime, break the government, but then have no viable, credible, government in waiting to take over that's got any degree of potential legitimacy at all, you get endless problems. I mean, the P3 have acknowledged that they screwed up the post-military phase of this. They've said, the peace-building phase wasn't particularly brilliantly handled. They've never conceded that maybe we shouldn't have got there in the first place. But it's a long and complicated story, but I think you're right in pointing to these multiple dynamics that are at work in these situations and how careful we've got to be. Very, very careful you've got to be before plunging in with the military stuff, because it can go terribly wrong.
Thank you very much. I'll move for that. A last question. Maybe the lady. And then have the last word.
Okay.
Or if you can stick with us, maybe another 3 questions, but short questions.
That's okay.
Okay.
And short
Thank you very much,
answers,
Tobias. My name is Netta. I'm a graduate of the ANU and a humanitarian lawyer working here in Geneva. My question relates to the second pillar of R2P. I think that classically, like when I was taught R2P, as Tobias said, we were taught that the second pillar relates to invitations from an affected state, a state in which a mass atrocity is occurring or is imminent, for support from other states to respond to the risk of that mass atrocity and ideally prevent it in some way. But do you see Pillar 2 as having a broader scope, and could it encompass other kinds of initiatives? And I'm thinking in particular, does it have a negative element, like a responsibility on states to refrain from doing certain things when those actions could facilitate mass atrocities in a particular country? For example, refraining from transferring weapons.
Well, that's a very good thought. I mean, Pillar 2 has always been cast in terms of positive forms of assistance, and I don't think people have particularly thought about in that case, but that is part of the logic. I mean, you're not assisting, you're actually doing the contrary of assistance by fueling things potentially with conventional weapons supply or whatever. So that's an interesting thought to put into the mix, and one that's worthy of discussion, I think. The point about the second pillar is that it really is potentially very, very broad indeed. And one of the things that, of course, the second pillar encompasses is military resources being made available to a state at its request to deal with a situation which has got out of hand. So, we tend to think of the military stuff only in the context of the coercive intervention externally imposed. But there are some situations, and we've seen a few of them, Boko Haram and Nigeria and so on, where, the Indonesians at least technically sought the Australians and others to come in and help them resolve the problem in, these Timorese, the Indonesians, when the Timorese situation blew up. So, I mean, it's got a number of different dimensions to it, all of which I suppose are context specific. And the negative dimension is one that I hadn't really focused on before, that does make some sense to discuss also in this context, I guess. Because, you know, it's the part of this larger notion that we have a collective responsibility to ensure that this stuff doesn't happen. And if there are obvious strategies that are fueling a situation that's potentially explosive, then surely it is part of the responsibility of other states to step back from that role. And I think that's a very good point that you're making.
Thank you very much. Okay, yeah. And then another one. Is there another question? Just the gentleman with the light jacket efforts, and then we can...
My name is Walter Mandela. I'm a PhD student at the Graduate Institute.
Could you speak up a bit, please?
My name is Walter Mandela. I'm a PhD candidate at the Graduate Institute. My question is, you mentioned Chapter 8, where regional organizations can deploy, can intervene in states. And of late, some scholars have been arguing that there's now customary international law that's developing whereby regional organizations can intervene without Security Council resolution, as the case was with ECOWAS intervening in Liberia and SADC in Lesotho, and the Security Council did not condemn this and actually congratulated them for the work done. So my question is, what's your stand on this? Do you think that this customary international law now evolving whereby regional organizations can actually intervene without Security Council resolution?
I think there's some truth in what you're saying. For a long time, Chapter 8 which requires, of course, you can do stuff at the regional level, provided it's with the support of the Security Council, with the approval of the Security Council. For a long time, that's been understood as including later authorization, ex post facto, for something that you do, and then you go to the Security Council later on. And by and large, that's tended to be what's happened when ECOWAS, in particular, has done a number of these crucial interventions in West African situations, for the most part with pretty positive results. I don't think in any of them it's gone to the Security Council first, but in most of them, if not all, and I'm not sure, your thesis will no doubt be addressing this, but in most of them, certainly there's been some form of acknowledgement by the Security Council afterwards, whether it's applause or just noting, or it can be counted as a kind of approval. But I sense that that's become more and more of a sort of a formality, and perhaps less often the case in practice. So maybe we are seeing something in the nature of an evolution of a customary principle that because that's happening more generally, a recognition that the old subsidiarity principle and so on, that you can do a lot more effectively in many of these contexts by divesting the responsibility to the regional level. The problem is, of course, as you look around the world, there's very few regional organisations that have behaved with anything like the efficacy that ECOWAS has in West Africa. I mean, ASEAN is a bust, I'm afraid. SARC is non-existent in South Asia. SADC has been useless with Zimbabwe and others in South Africa. Maybe the East African one's a little bit more active, but so I mean, if we are going to talk about regional organisations and a developing body of custom and practice about what they can do, it'd be helpful if the regional organisations themselves showed a bit more visible, credibility in their performance. But it's a very interesting point that you made. I hadn't thought of it in those terms. I'd been thinking of it in terms of it being pretty much a formality, the ex post facto dimension. But maybe it is the case that we're getting to the stage where this stuff is sort of self-executing, the authority of the regional organisation itself, and that's probably no bad thing in terms of having effective, quick response. Because if you can get the countries that are invariably going to be most immediately affected, having that sort of commitment to doing something about these sort of situations, that's likely to be far more effective if it's well done than relying on other people to come from the other side of the world. It's a very interesting point.
Hi, my name is Peter Splinter. I was formerly the representative of Amnesty International here in Geneva. When Rights Up Front was first announced, it was touted as a major contribution to prevention of mass atrocities. The UN seems to have abandoned Rights Up Front. What effect do you think that will have on the UN Secretariat's ability to contribute to prevention of mass atrocities?
Has it abandoned it? I don't know. I was living in hope that there would be some resurrection and some content given to some of the declaratory stuff, but we haven't seen much of it, I'm afraid, from the current administration, which is operating in a very, very difficult geopolitical environment, of course, but there's not been any formal abandonment, has it? It's just sort of drifted away into the... I don't know. Well, I mean, it would obviously be a bad thing if this stuff is, not given renewed attention. Every time anyone writes or says anything in a new UN context about responsibility to protect, it's prevention is at the heart of the rhetoric. Getting it to the heart of the substance will be consummation devoutly to be wished. But beyond that, I can only agree. I mean, I'm troubled by the thought that has drifted away as a priority, because it was a very, very important element in Kofi's legacy and Ban Ki-moon's legacy, Ban Ki-moon's under-recognised legacy. I think that he was pretty serious about this stuff. Might not have been very effective, but he was very serious. Now I'm not sure whether it's either effective or serious, but that's another question on which the jury, I guess, is still out.
Okay, so for the third time, the last question, maybe, gentleman in the back, but now seriously. But thanks so much, really, for your engagement.
I do apologize for coming in, but I'm Moses Kevin, Deputy High Commissioner of the Rwanda Mission in Geneva, and we had a cross-regional group of states on the responsibility to protect, the group of friends of responsibility to protect, which you referred to. But I'm prompted by a question, just to follow up on what Peter just raised, and what you have just said in response, Gareth, and thank you very much for all that you've shared on the responsibility to protect. We're looking at how we can implement at least Pillar 1 and Pillar 2 here. It's a cross-regional group of states, Netherlands, Australia, a number of states from Latin America, Africa as well, West Africa, ECOWAS states, and we're looking at how we can realize that prevention mandate within the Geneva space. That is within the context of the Human Rights Council. Some of the mechanisms the Human Rights Council has put in place to prevent situations of gross violations of human rights, mass atrocities in Central African Republic, Myanmar, and in other spaces, and in the humanitarian space as well. But we continue to struggle with the implementation of that prevention mandate. And I wondered if you had any thoughts or any suggestions on how we can better do that. Even within this group of friends, we struggle to get consensus on statements in the context of the Human Rights Council on situations. We had a special session on Myanmar a few months ago, and it was almost impossible for us to garner a statement out of the 60 or so members of the group of friends on the responsibility to protect on a situation that is very obviously a mass atrocity case. So do you have any suggestions on how we can move that discussion forward within the context of the Human Rights Council and the humanitarian discussions? Thank you.
Well, getting the Human Rights Council effective is a bit above my pay grade, I'm afraid. I've absolutely no idea what to do about the Human Rights Council. I was party to the discussion in the high-level panel, and we went through all sorts of formulae for election and so on, but when you get people bringing these agreed slates, so there's no opportunity for any kind of vote on any country's individual credentials to be on the council, that's not a great start. And when you're, one of the great things the Human Rights Council can do with its mandate and with the Commissioner, obviously feeding it and with the resources available to do it, is prepare these reports, which basically are identifying problems not only that have happened, but are problems in the making, things that are going wrong and are crying out for attention. If you're talking about effective prevention, the documentation and the visible neon lights documentation of particular deteriorating situations is a critical part of that. And within the Human Rights Council sort of mandate and the institutional mandate of the Commission, there is a capacity to do that sort of stuff. But if, as you say, this is breaking down endlessly on arguments about language and what's acceptable and so on, it's not having much real impact, is it? So I don't know. It's the same question I was trying to answer before. We're all in the effective prevention business. we all know what the toolbox is. We know the two trays. It's the long-term structural measures, the short-term operational measures. We know there's a legal and constitutional dimension. We know there's an economic dimension. We know there's a political governance quality dimension. We know there's a security sector dimension. And, you know, and operationally and structurally, short-term, long-term. There's a million strategies that are out there, a million strategies that have been documented, and a million, dozens of organisations and countries that have got notionally the capacity and the responsibility to implement those various strategies. But making it happen, I don't know. That's your job. I'm just an old greybeard. I'm clapped out. I've had it. I don't know what to do. I just sort of, you know, rage. But basically, the responsibility is of the next generation to make this stuff happen. And don't let the achievements that we have made slip away because of a cynicism and a despair that it's all been a waste of time. Don't let that cynicism and despair take over. You know, believe in the basic decency that people just don't want to see this stuff happening. You know, and Rwanda's got a particular responsibility in this respect. I mean, you know, it is the case that there's still a lot of, I mean, Rwanda's been terrifically supportive of R2P, terrifically supportive as a, you know, the Friends group in New York and elsewhere, but there is this lingering, you know, perception, not entirely without justification, that, you know, there's still a few unanswered questions about the DRC intervention and everything that's followed from it, and still some, you know, some difficulties about the way the place is running at the moment, even though the economy is going gangbusters and you're making a fantastic contribution in other ways. So there are issues of this kind that, you know, everybody's got to wrestle with and respond to, and you know, it's not easy. But you know, what we have to do is focus not on that which divides us, not on that which, you know, can be the subject of criticism, but rather that perhaps it's small, perhaps it's only just a tiny core of stuff that we can actually passionately agree about. And it was my perception when running this whole commission and everything else that's followed, it was my perception then, and it's my perception now, that there is still a potentially huge reservoir of agreement internationally to repeat that whatever else we stuff up in the conduct of international affairs, don't let's stuff up again when it comes to seeing the unfolding of these terrible Holocaust, genocide, mass atrocity crimes. Because it's just indefensible from whatever point of the political ideological spectrum you come from. This stuff is just an indefensible assault on our common humanity. So hang on to that little bit of flame and just try desperately to find ways of operationalising it, and hope that the wheels will turn with some of these larger geopolitical things which are at the moment standing in the way of effective cooperative response. So hang on in there.
Thank you very much, Professor the Honourable. Thank you very much. There's not much to resume about, because it's really it's great how you put things in place, and thank you very much really for this amazing scan of issues and insights and thoughts, etc. I'm just looking at the report, the responsibility to protect, and what to me is occurring a little bit. I suddenly like see the aspect of responsibility, and so the responsibility of us all, the responsibility, as you said, also of the newer generation, of those that are really working on these issues now, and so really thank you much. Yeah, it's for you. It's actually 4 o'clock in the morning. So I guess this was a pretty long day, and so I would say, like, finally, let's call it a day. Thank you so much, really, Professor Honourable. Thank you so much for being with us today. Thank you so much for making the efforts. Thank you so much for lending yourself also to a debate, which is much harder than just reading down PowerPoint slides. Really, thank you very much for being here. Also, special thanks to Alessandro, who was really a driving force behind this event. Thank you very much to Jan and many other GCSP colleagues sitting there that had prepared on many things. So really a special thanks to that. Also, thank you, distinguished guests, for being here. It's already dark. I mean, it's getting winter, but still, you're here when it's dark. So thank you very much. The next Security and Law reality check will be on hybrid warfare on 7th December. Maybe that could be interesting too. The question is simple: what is hybrid warfare? Is this a valuable concept, or is this just some kind of hype among security experts? And the other question there really is this something just for Brussels, where you have NATO and where you have the European Union with their priorities, or is it something that Geneva should start thinking about and if Geneva is a capital of human rights, IHL, disarmament, humanitarian affairs, etc., well, how can this concept or how can this thinking inform our work and maybe eventually even inform our responsibility? So thank you again for being here. Hope to see you again, and thank you again for all the efforts and for being here. Have a nice evening. Thank you.